Good morning, Your Lordship.
Yes, board, go ahead.
My lord, your lordship will recollect on the last order. Am I audible, my lord?
Yes,
Am I audible, your honorable chief?
Yes. You're audible, loud and clear, sir.
My lord, your lordship will kindly see order dated 19/12/2022.
1912. Okay.
2022.
Yes. That is after dismissal of the review petition.
Yes.
Yes. Please read out. Please read out.
Heard Mr. Takamasa, learned amicus curiae.
Yes.
Also heard Mr. Borgohain, learned counsel for the NHIDCL, and Mr. K. Nikang Michael, learned counsel for respondent number 8, as well as Mr. Arora, learned counsel for respondent number 12.
Just hold on, sir. You are referring to order dated 19 December.
19 December 2022.
I don't have that order in the file. It may be in the file.
is the last order.
Brother, I have it because the files were received very late yesterday. Anyhow, yes, carry on. Now I have that order. Yeah.
Had Mr. Takamasa, learned amicus curiae, also had Mr. Borgohain, learned counsel for the NHIDCL, and Mr. K. Likang Michael, learned counsel for respondent number 8, as well as Mr. Arora, learned counsel for respondent number 12. The respondent number 12 has filed an additional affidavit this morning, and it is brought on record. We make it clear that the IA filed by the respondent number 12, that is IA Civil 203 of 2022, shall be had finally on the next returnable date. The NHIDCL also filed an affidavit on 14/12/2022.
Wait a minute. If we have a look at the documents of the IA, we find that the IA has been disposed of. So, what is to be heard on that IA now?
Lordship, where on the main petition?
Okay, main petition.
Main petition.
Review has been disposed of. Yes.
The NHIDCL has also filed an affidavit on 14 December 2022, indicating the steps taken by the NHIDCL authorities on receipt of the amount of rupees 11 crores 12 lakhs. The details are indicated in the affidavit, and we are satisfied.
Yes.
Pursuant to our earlier order dated 14/12/2022, by which the NHIDCL authorities and the respondent number 8 were directed to have a deliberation about the package 3, particularly taking into account the public interest involved, and as the package 3 has become a non-starter causing a lot of inconvenience to the commuters. The parties had a deliberation on 16/12/2022. The respondent number 8 has given 3 proposals in their letter dated 18/12/2022, along with project cost estimate. The NHIDCL authorities praised for some time to look into the proposal and to further deliberate with the respondent number 8, and thereafter to take a decision at the highest level as to whether the proposal made by respondent number 8 is acceptable or not. The General Manager NHIDCL, who is also present in the court today, submits that if the proposal of respondent number 8 is not acceptable to the NHIDCL, they will take further steps to bring out a better option for the completion of package 3. He also assures this court that the 2 lane with regard to package 3, which is presently under maintenance, shall be completed before March 2023 as per the project specifications. Recording the submissions made by the learned counsel for the parties involved, that is the respondent number 8 and the NHIDCL authorities, we give time to the parties to have a deliberation and come to the final decision on or before 15th of January 2023. Thereafter, the NHIDCL authorities shall file an affidavit with regard to the outcome of the deliberation. Further, in the said affidavit, if the proposal made by the respondent number 8 is not acceptable to the NHIDCL authorities, they shall also bring out the alternative proposal for completion of package 3. The said affidavit shall be filed on or before 17/1/2023. This is the matter on 19/1/2023.
Yes.
IN number 178/2022 was disposed of on 14/12/2022. In the said order, we directed the respondent number 8 to raise the bills and have a joint verification with the NHIDCL authorities. And thereafter, the agreed amount of pending bills shall be released to him on or before 21/12/2022. We make it clear that while releasing this agreed amount, no penalty amount should be deducted from the said bill. However, some penalty amounts can be deducted in the final bill. taking into account the concessions made by this court, we directed respondent number 8 to ensure that package 1 and 2 are completed on or before 15th of January 2023.
Yes.
After this, what happened, my lord, the matter could not be taken up because no appropriate benches have been constituted.
Right.
Now we are in the month of March.
True.
Now, your lordship, let me be very, being an officer of this court, let me bring certain facts.
Sure.
Your lordship, the matter was been taken under suo motu PIL. Because of larger ramifications as far as this project is bearing not only in the state of Nagaland but over the length and breadth of this part of this notice. The learned senior counsel has been appointed as Micah's Query. Now, there are some peculiar problems attached with this project because the topography issues are there, and moreover, the bidding process.
Yes.
We call for the bidding NIT, but the parties who bid here, they bid exorbitantly negative bidding, which is frustrated the project. My lord, my hands are tied. NHIDCL hands are tied because your lordship is well aware that we have to go by the lowest bidder, L1. And that has proven to be a very detrimental to us, particularly in this area. That is number one. Number two, your lordship, the records will reveal that earlier on 2 occasions, 2 parties have taken part in the bidding. That is one was Gauhati.
Gayatri.
My lord, even the court went for initiating contempt proceeding. Now what has happened is that we are having an arbitration proceedings. Now second comes Mr. Oasis, MS Oasis. Your order sheet reflects what has they have done.
Yes.
Now, being alive to these peculiar circumstances, the learned senior counsel, my senior learned counsel, being Amicus Curie, and the honorable court, after thorough deliberations, that let us go to an out of the box. So out of the box was there, as far as package 1 and 2 was concerned, that was been done by the respondent number 8. That
Right.
since he has all the infrastructure at that point of time, can this man be asked to work on package 3 also?
Package 3 also. Yes.
My lord, with all sincerity, we did our deliberations. But the amount they have proposed to us, it is far beyond the bill I can fetch at this point.
Okay.
Then, my lord, since the matter was related on 15/1/2023, but since the benches could not be constituted,
Right.
we had no option. We have to call for an NIT again. But your lordship will be, I believe, Honorable Justice Jamir was alive to this question, has put to me that Mr. Borgoy, that if a subsequent NIT, if again a negative bidding will come, what will you? I told him, my lord, I cannot do anything until and unless your lordship take a discretion under 226.
Right.
Now, my lord, we assured the court for a larger public interest that at least the 2-lane work of package 3 will be going ahead. We will give it. And I must say, we are all arrived to this thing that as far as package 3 is concerned, 2-lane, the work is almost completed. Only 500 meters of work is left.
Okay.
And the contractor who has been given MNR, maintenance and repair work, they have done it. Only 500 meters is left. So, but now we have floated a NIT, my lord.
Right.
NIT. Now my colleague, Mr. Joshua, who is representing the package 3 contractor maintenance work. On the earlier occasion, we asked, the amicus asked that let the Chabu and Co. that be implemented in this matter. But so for some reason, in the order sheet, it was not reflected.
Okay.
Now they are coming that they came since they were all alive, that since package 1 was asked to work on package 3, why can't we be given that work?
Right.
I told that decision I cannot take. That is, I am putting it before this court.
True.
The engineers are there because we have to find a middle way. And most pertinent question is there, my lord.
Yes.
Larger public interest is involved. Number one.
That
Number
is why
two.
we have taken suo motu.
That
is why.
My lord, second issue is that the G20 is coming. The pride of our country. It is coming on 4th and 4th.
G20 is one thing. The convenience of the public at large who is suffering for years together, that is another. So
My lord.
our graver concern should be for the inconvenience which the public is facing for years together.
My lord.
G20 is all right, another feather in the cap, but ultimately we are answerable to the common man.
My lord.
Yes.
Oh, well, lordship, what I want to make a prayer is that
Yes.
since this matter will be requiring a in-depth hearing in this matter, all the issues are there. I will, we had a discussion with amicus and all the stakeholders, is that through virtually it is difficult, my lord.
Difficult. I understand. I
My lord,
understand that. Yes. So
if
we
your
will try to fix up a date very shortly, where myself and Brother Justice Jamir can be together to hear the case physically. But for the present, Honorable Justice Jamir would be giving some of his ideas how to go about the things. Yes, brother.
Yes, okay. Mr. Borgohan,
my lord,
one question is, are you satisfied with the work that is being done at package 3 by the present contractor?
Respond number 10.
we are satisfied, my lord. My team is here, the engineer is here, team leader is here, we are satisfied.
Are you willing to enter into a deliberation with the present contractor for the completion of the whole work?
Your lordship, if your lordship pass that order, then I will be having a deliberation, right away.
All right.
Lordship, may I intervene here?
Yes, please.
The issue is, my lord, after the order passed on 5th of December, 19th of December, the matter was fixed on 19th January. Now, because of the absence of appropriate bench, the matter could not be heard, subject to repetition. In the meantime, lordship, the NHITCL has gone ahead and floated an
We have
NIT.
heard that. We have heard, Senior Counsel. We have heard that. Yes.
In that issue, in that background, my lord, whether when the NIT is yet to be opened on the same project, whether to go for deliberation, unless and until that NIT is withdrawn.
If everyone has the larger interest of the public in mind, then yes, we can take a call under 2 to 6 and say that the NIT proceedings would be put on hold because 2 earlier attempts have already failed. We can very well say that. There is no difficulty in that. So what Brother Honorable Justice Jamir is saying is perfectly justified. Let the NHIDCL have a deliberation with respond number 10 on the feasibility and the viability to get the project completed from the said contractor, because the contractor already has significant experience on this very road. And as we have been told that the 2-lane project he has completed, the contractor has completed satisfactorily. So why not a deliberation? Why this hesitation on part of the amicus curiae?
My lord, the issue is, since it is for this honorable court to make a call, that's why I'm making my humble submission. If that is the view of this honorable court, lordship, then let Jabo and company be implemented as a party. Yet they are yet to be, the maintenance contractor is yet to be implemented as a party in the present PIL. Let them be implemented, and then lordship, because
No, this is not an adversarial litigation so far as respond number 10 is concerned. It is simply
lordship, my apology, lordship. The maintenance contractor is yet to be implemented as a party responded in the case.
we have heard you, sir. We have heard you. Then that's why we are expressing that the maintenance contractor. This is not an adversarial litigation that he has to be implemented, that any adverse order is to be passed against that contractor. It is simply the expression of the court that why not explore the possibility of the respond number 10 completing the work of the project 3.
My lord, your lordship, as far as respondent number 10, your lordship
No,
is there.
not respond number 10, the maintenance contract. Yes,
Yes, my lord, yes. That is critical condition. And your lordship, if your lordship pass that order to have a deliberation, and if your lordship may fix up a matter on a short date,
Yes.
it will be very much convenient for all of us. Number
And the
one.
result, yes, we as honorable my brother Honorable Justice Jamir has already expressed, he is having the idea of the ground situation much better than I am. As my lord has expressed, let us have please go through with the deliberation and present the result in a sealed cover for the court to peruse. Let it not be out in the open. It should be confidential, and thereafter we'll see the feasibility of going ahead with the things. Brother, what do you say?
Yes, Lordship, yes.
So, all right. Yes.
May I please, your lordships?
Yes, please.
You just
No, you please go ahead. Do you want a formal order of implement? Let us know.
let a formal order be issued, my lord.
That's it. That's it.
If my lords may kindly implement my client, the Chabu and Co, who are in charge of the Maintenance and repair works, lordships.
But whether any improvement is required, we are not proposing to pass any order against your client, Mr. Council.
Yes, lordship.
You have the deliberation, just hold on.
Yes,
You have the deliberation, let the result be placed in the seal cover for perusal of the court. Then we'll take a call whether you are to be implemented or not. Brother, what do you say?
Yes, that can be done.
My lord, and as per the NIT, your lordship has to pass an order.
Yeah, NIT has to be put on hold presently because can you give us a vague idea regarding how long the NIT proceedings will be take to complete, and thereafter what is the tenure which is to be given for construction of the road?
Your lordship, as far as package 3 is concerned,
Yes.
we have called up the NIT for 146 crores for 2 years, my lord.
2 years. Now just have a look at it. As you said, that 2 of the earlier NITs, the pricing was in the negative, so you couldn't succeed. What is the guarantee that this NIT would succeed?
My lord, your lordship is fairly correct, and I appreciate that. My lord, your lordship must appreciate my position. My since I
understand.
I have to go ahead.
You are dealing with a commercial transaction, we can understand. But this matter is being taken up in public interest. So we will try to ensure that the public interest is of paramount consideration
My lord,
for the court and for everyone concerned.
your lordship.
Brother, you can pass the order, please.
Yes.
I'm so sorry, my lords. If I may, my lords, I beg to appear, my lords, for respondent number 12.
Yes.
My lords, respondent number 12 was one of the erstwhile contractors for package
Yes.
3. My lords, in this case, there's an IA that we filed which is currently pending.
203.
That's correct, my lords. My lords, we were directed to liquidate 10% of the contract amount, which is 11 crores,
Right.
which we have deposited before the Honorable Court pursuant to the directions.
Yes.
My lords, there's an application that we filed where we beseech the Honorable Court to reconsider the order, and
Right.
we're asking for a vacation and a modification, and for release of that amount. My lords, the basis of that request being, my lords, that in this case, in our respectful submission, and I say this with great responsibility, my lords, there has been no disobedience, let alone, my lords, willful disobedience in that sense.
How
And my
much of
lords,
work your client has done, Mr. Chug?
my lords, in this case, as my lords have said, this is not an adversarial proceeding. The
The
Honorable
earlier
Court
orders,
immediately-
if you go through the earlier orders, this court has observed that your client did nothing except for buying time on one pretext or the other.
my lords,
You
with
put
great
your
respect.
affair on hold for a while. Let us first see the feasibility of getting the road constructed. That is what is
My lords,
of prime.
I'm so grateful for that, my lords. May I just point out one thing, my lords, there.
Yes.
My lords, we filed a detailed affidavit on record, demonstrating how this is not a case where this is a willful disobedience.
Yes.
My lords, in this case, there are multiple factors which prevented me from performing this contract, many of them outside my own hands.
You've
And my lords,
been
there's
to
one
Supreme Court
subsequent
also.
development, my lords, which may be important.
Just interrupting you. You've been to the Honorable Supreme Court also in relation to the very same issue.
That's correct, my lords.
What
And
was
the
the
Honorable
order
Supreme
passed?
Court, my lords, that's correct. And the
What was the
order
order
said, my
passed?
lords, the order said that I would be at liberty to place an appropriate application for vacation before this Honorable Court, and that would be decided, my lords, because this is a substantial amount. And my lords, one subsequent development which is of importance, and I must put this on record, my lords, this is a dispute that actually arises out of a contract, my lords, which is an arbitration clause.
That you
The
mentioned in the
High Court has
application.
appointed an arbitrator, and Justice Sareem's been appointed as the arbitrator who's currently seized of the matter.
Right.
My lords, and I also say this not in the spirit of an adversarial proceeding, my lords. There are narratives and counter narratives. One narrative, my lords, is that I am in breach of the contract.
Right.
There's another narrative that there is breach on the part of NHIDC and also force majeure. There are hundreds of letters exchanged by both the parties.
Right.
They've also declared me a non-performer. They invoked my bank guarantee. All of these questions now are before the learned arbitrator. My lords, my only request would be that this question of appropriation or release of 11 crores, and it's a substantial amount, my lords, may also be relegated to the arbitrator, because after all, at the end of the day, these are disputed questions of fact, and with great responsibility, my lords, they may not be amenable to a writ jurisdiction.
We'll consider your prayer on the next date. We'll consider your prayer on the next date. Yes, Mr. Counsel, you were saying something?
Your lordship, since my learned colleague was making the submission of repatriation of the liquidification of 11 crore, your lordship, your lordship, Justice Jamil is well aware, and the order sheet was reflect that they, when they were moving the application, especially on 12th of October 2022, on the same day, the matter was listed for this bench. and the senior counsel has suppressed this fact. Senior counsel has given a rosy picture. I believe, I believe that my colleagues have misrepresented or misinstructed the senior counsel. They have taken this court for a ride in institution.
We'll see, Mr. Council. We'll see.
I'm so sorry, Manu, extremely unfortunate.
Grounds, the prayer which is being made is on the ground that once the arbitrator is appointed, everything has to be done by the arbitrator. What is the court supposed to do? We'll consider a prayer now on the next date. Firstly, let me on the substantial issue of getting the work done. Yes, sir, please proceed. And now, no one need to interrupt the order.
Also heard the learned counsels appearing for the respective parties. Stop. Para. Mr. Borgohan, learned counsel for NHIDCL, submits that pursuant to the order dated 19/12/2022 passed by this court, the parties, the NHIDCL had a deliberation with the respondent number 8 with regard to package 3. However, no finalization could come, and the NHIDCL had to proceed with floating a NIT dated Borgohan
Hello. Dated 2nd February.
dated 2nd of February 2023. Stop. For an amount of rupees 146 crores for package 3. Stop. To a pointed question made by this court, Mr. Borgohan submits that presently one MS Chapu and company is maintaining the road with regard to package 3, and they are satisfied with the work done by the said company. Stop. Considering the public interest involved and also the plight of the commuters, particularly involving two states of Manipur and Nagaland, we direct the NHIDCL and the Chapu company to enter into a deliberation as to whether they can proceed with the finalization of the work for package 3. Stop. Lordship, how much time should we give them?
Let's ask Mr. Burgoyne.
Lordship, if your Lordship give us the order today itself, looking at all the things, my Lord, we can have the entire thing done within a week's period of time.
Very well. 7 days time, brother, we can incorporate one more thing in the order, that while considering making the deliberations, all parameters of eligibility of the contractor in lines of the NIT will also be kept in mind.
Yes, while making the deliberation, all the parameters in light of the NIT should also be taken into consideration by the NHIDC. Stop. Let such deliberations be done and on or before a period of 1 week from today. Stop. The result of the deliberation shall be submitted to this court in a sealed cover by the next returnable date. Stop. In the meantime, we also direct that further proceedings of the NIT dated 2nd February 2023 shall remain suspended for the time being. Stop. List the matter again.
Brother, we can have the hearing in Gauhati in the next week. Is it possible?
And your Lordship has to call my senior amicus has to come up to Gauhati.
On 22nd, Lordship, 22nd March?
Yes, 22nd would be fine, sir, but at Gauhati.
Yes.
Yes.
On 22nd March.
Yes.
All right.
Thank you, Lordship. Thank you.
Well, maybe it's Lordship.
Yes, please.
Lordship, I beg to mention item number 19. And this matter was heard by Justice K. Sema on 3 occasions. And on his direction, affidavit is also filed. So if I pray that, I may pray that this may be heard by Mr. K. Sema.
Is a parted matter.
He has not reflected as part heard.
Well, I'll just adjourn it. I can't direct it to be listed before.
Otherwise, he has heard the matter on 3 occasions.
Okay. On request made by Yamawati, then the counsel for petitioner, list the matter after 1 week. So after
Matter.
1 week. we'll come.
Master Lordship.
Will you please, Your Lordship?
Yes, please.
Your Lordship, I beg to mention admission item 7. I'm here to file counter. Let the matter be listed after 3 weeks, Your Lordship.
Yes. Who appears?
Yamawati, Your Lordship.
Yes, Lordship.
Yamawati, then the counsel for petitioner. MS Lucille, then the senior governor. Okay, this amount. How much time you require?
3 weeks, Your
3
Lordship.
weeks time to file counter.
Lordship, there is an interim order.
List after 3 weeks, interim order possibly to continue.
Also, item number 24, Your Lordship. I have taken the consent of the petitioner. Let the matter be listed after 3 weeks, Your Lordship.
Yes, Lordship.
Clerk Subhamati, then the counsel for the petition. On request made by Ms. Lucille, the senior governor. List the matter after
3 weeks, Your
3
Lordship.
weeks.
Obliged.
My best Lordship, I beg to mention today's item number 13. I pray that may be passed over tomorrow.
On request made by Subhamati, then the counsel for petition. List the matter after 1 week. Tomorrow we will.
Yes, Lordship. Obliged, Lordship.
May I please, Your Lordship? Lordship, may I be pleased to mention item number 16, 16.
Yes.
Your Lordship, 3 weeks may be granted to me so that I can file my affidavit, Your Lordship.
You are appearing. Your good name?
Livika, Your Lordship.
Your good name?
Vivana. Your Lordship, I'm appearing on behalf of my senior counsel, Moajamir.
More Jamil and the counsel for petitioner. On request made by MS.
Livika, Your Lordship.
And the governor. List the matter after
3 weeks, Your
2
Lordship.
weeks to enable her to file counter.
Much obliged, Your Lordship.
Lordship, I'd like to mention item number 21.
Yeah.
Lordship, if this matter can be fixed on 28th of this month, we have taken the consent of the opposite party as well. This matter.
Yes, Siti Jamir.
Let it be on 21st, Lordship. That is Tuesday.
Okay. You are Mr.
Akriu Chisi.
On request made by Akur Chusel and the counsel for petitioner. List the matter on 21st March.
Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 15, Lordship. Lordship, the state is yet to file counter. 3 weeks time may be granted, Lordship, to file counter.
Third, Akre, learned counsel for petition. On request made by Mr. VZ, learned government advocate. List the matter after 3 weeks to enable him to file complaint.
May I please, Your Lordship? Lordship, I beg to mention item number 10. If 3 weeks' time can be granted to me, Your Lordship, to receive the necessary instruction, Your Lordship. I've already taken the consent of the other side, Your
You
Lordship.
are appearing for respondent
Number 1.
on request made by Enangam, learned government. Learned counsel appearing for respondent number 1. List the matter after
3 weeks, my Lord.
3 weeks.
Deeply obliged, my Lord.
May I please, Your Lordship? Yes, I beg to mention one unlisted item. Your Lordship, IA 22 of 2023. Your Lordship, order dated 20th February 2023, passed by this honorable court, has not been complied with. So, Your Lordship, I pray that this matter be listed on Thursday. This IA.
What IA?
Your Lordship, IA is for stay of the developmental works that is going on. This honorable court has by order dated 20th
You have the
February.
mentioned memo.
Yes, I have the mentioned memo.
Submit.
Please, Lordship, Lordship, I beg to mention item 11.
Hmm.
Lordship, this matter, the state as well as the private respondent, they have filed an appeal before the Supreme Court. So, Lordship, I pray that this matter may be listed after the
Is there a stay order?
There is no stay order, Your
No,
Lordship.
Lordship.
But Lordship, as a propriety, Your Lordship, the matter is
No,
not
no, no,
pending.
that's not a question of propriety.
Yes, Lordship.
Yes.
Lordship, and on the last occasion also, they were directed to file their
Lordship, if
affidavit,
that is the case, I may be given 3 weeks' time to file my affidavit, Lordship. Then.
Heard Mr. Tushi.
Yes,
Comment
Lordship.
on the counsel for petition. MSV Sukri, learned counsel, appearing for respondent
For-
number.
For all the respondents,
Appearing for all the respondents is allowed 3 weeks' time to file affidavit. List up to 3 weeks.
Lordship, I have a similar prayer in item 12 also. Item 12.
Tongpok, Pomonar,
So, item 12. 3 weeks' time may be given to me to file my affidavit, Lordship.
Lordship, on the last occasion, I had produced one letter which was issued by the director. Here, he has clearly written that the case of the petitioner cannot be considered, despite the order of the direction of this honorable court. So it is on record, on the record. So it is, if it is not, if within 3 weeks, if they don't reply, then the respondent number 2 should be directed to appear personally. Your Lordship.
Heard Tongpok, Pomonar, learned counsel for petitioner. MSV Sukri, learned counsel, appearing for
For all the
all the
respondents.
respondents is allowed. How much time?
Lordship, in that case, 4 weeks, within
weeks'
that,
time.
yes, I'll
As
prepare.
last chance.
Your Lordship.
To file affidavit. List of the 4 weeks.
Lordship, again, item number 18. Lordship, here I may be given 3 weeks' time to obtain the status of the case.
Okay, let's Gauhati, learned counsel for petition. MSB on request made by MSB Sukri, learned additional AG, Nagli. List the matter after.
3 weeks, Your Lordship. Much obliged.
Oh, you are not the additional AG, you are in the contempt, no?
Lordship, as an additional AG also, Your Lordship. Yes.
My Lord, please allow me to mention item number 20. On the instruction of the senior advocate Esjata, my Lord, mechanically on 3rd of April.
On request made on behalf of S. Dutta, learned senior counsel for the petitioner. List the matter on 3rd of April.
May I please, Your Lordship? I beg to mention item number 6, Your Lordship, on behalf of the council for the respondent number 1 and 2. Your Lordship, she is indisposed, so kindly list this matter after 3 weeks.
Third, Lucina, learned counsel for petitioner. On request made on behalf of Apila Sanctum, learned counsel for the respondents 1 and 2. List the matter after
3 weeks.
2 weeks.
Lordship, if I may be allowed to make a mention of item number 4 and 5, Lordship. Lordship, here the state has already filed, and the union they're saying they will not file. So this can be listed for admission hearing on Monday, Lordship.
request made by Ms. Lucina, Learned Counsel for Petition. List the matter on
20
March
20 March, Lordship.
for admission.
Much obliged, Lordship.
Much obliged.
Yes, Lordship. Lordship, I beg to mention for item number 1, Lordship.
Yes,
On behalf
everything.
of the counsel for the petitioner, Vikram Depnath. Lordship, he has fractured his elbow, Your Lordship. So because of which he cannot travel today, Your Lordship. So if Your Lordship, we kindly list this matter after 3 weeks, Your Lordship.
On request made on behalf of Mr. V. Depnath, Learned Counsel for the
Petitioner.
appellant. List the matter after
3 weeks, Your Lordship.
3 weeks.
Much obliged.
Your Lordship, I beg to mention item number 17. On behalf of Inauli, kindly grant 3 weeks' time to file affidavit.
Yes, heard Lakshan Tila, Learned Counsel for Petition. On request made on behalf of Inauli, Learned Government, list the matter after 3 weeks to enable her to file complaint.
May I please, Your Lordship? May I please, Your Lordship? I beg to mention item number 23 in the part 2 list.
Yes.
Lordship, the principal counsel is indisposed. Let it come after 2 weeks, Lordship.
On request made on behalf of NK Local, Learned Counsel for Petition, list after 2 weeks.
Lordship, I also beg to mention item number 14. We are yet to file affidavit in opposition, Lordship. Give us 2 weeks' time.
Mr. C.T. Romson, Learned Counsel for the respond number
Respondent number 5, Lordship.
5
Lordship.
is allowed 2 weeks time to file contract. List after 2 weeks.
Lordship, there's a status quo order here.
Status quo.
Lordship, there's an
Status quo
interim.
order passed earlier to continue till the next week.
Lordship.
For admission, item number 2.
May it please your lordship. My lord, the issue on Rule 31, whether Rule 31 of the Rules for the Administration of Justice and Police in Nagaland, whether appeal lies before the district judge or his subordinates or his assistants under Rule 31 of the rules or not, is an issue that is placed before the Honorable Chief Justice. Now, my lord,
It is already placed.
I believe it's already placed, lordship.
This has been referred to a larger bench in view of difference of opinion
Okay.
in various cases.
So we list it after some time?
Lordship.
My lord.
4 weeks?
Yes.
Lordship.
Request made by the parties, list the matter after 4 weeks.
Oblige your lordship.
Item number 3.
Lordship, on behalf of the Union of India, I have received the otherwise comments, but however, this is not very convincing, so I have returned it back. So I beg that I may be given another 3 weeks' time.
And Kumar, Learned Counsel for the petition. Mr. Yamawati, Learned CDC is allowed another 3 weeks' time to file contract. List of 2 weeks.
Yes, Lord.
Item number 8.
May it please, Lordship. Lordship, I'm filing my reply tomorrow, Lordship. If this matter can be listed for admission hearing next week, Lordship.
On request made by Moa Jamil, Learned Counsel for petition. List the matter after 1 week.
Lordship. Much better.
Item number 9.
May I please, my lord? Your Lordship, I am appearing for the respondent number 1 by order dated, Your Lordship, 21/2/2023. I was asked to receive the instruction with regards to the reconstitution of the committee, Your Lordship. I have received the necessary instruction. I may be allowed to place the document, my lord.
1 minute. Committee has been constituted?
Yes, yes.
When did you constitute the committee?
Lordship, the first committee, Your Lordship, was constituted on 21 December 2022. However, due to some communication gap, Your Lordship, this committee was not constituted as per the order passed in the writ appeal, Your Lordship. And therefore, this a new committee has been reconstituted again, Your Lordship. I may be allowed to place.
Lordship, may kindly see the paragraph 9 of the order dated 5 December 2022. Married, my lord. From the records as stated, it appears that the state respondents have taken some steps. Therefore, this court is of the view that they have not less deliberately ignored or neglected compliance of the directions given. Therefore, the respondent number 1 is once again directed to reconstitute the committee in the light of the submission made by Mr. T.P. Jamir and the other councils representing the other parties within a period of 1 month from today. After being constituted, the committee shall have the deliberations and determine the benefits to be given to the petitioners in terms of the direction given in the writ petition and the writ appeal. The whole exercise should be completed within a period of 4 months from the date of constitution of the committee. The Chief Secretary shall file a compliance affidavit. Now, prayer and Lordship, may kindly allow me to refer to the writ appeal judgment in the contempt petition. Lordship, may kindly turn straight to paragraph 33, page 33, paragraph 29 of the married Lordship. Paragraph 29. In that view of the matter, we direct the state government to constitute an expert committee to examine and determine the payment and entitlement of the financial benefits of village cards in consultation with the Ministry of Home Affairs, Northeast Division, Government of India. The expert committee should include representatives from the Home Department, Department of Personnel and Administrative Reform, Finance Department, at least 2 members from the Petitioners Association, the representatives of the Ministry of Affairs, Northeast Division, amongst others. The committee should be chaired by an official who is not below the rank of Additional Chief Secretary to the Government of Nagaland. The committee should be constituted as directed herein above within a period of 3 weeks from the date of receipt of certified copy of this order, and the committee should complete the process of examining the matter of enhancement of the honorarium and other allowances of the VGs as expeditiously as possible and not later than within a period of 4 months from the date it is constituted. While considering the matter of the enhancement of the honorarium and other allowances as directed here and above, the committee shall take into consideration the observation and direction given by the Apex Court in paragraph 39 in the case of Kra Raksha Welfare Association Supra. The recommendation by the committee shall be put forward to the state government in the Home Department and also to the Ministry of Home Affairs Northeast Division for approval and further necessary action. This was the direction, Lordship. The committee was constituted. However, the committee constituted, at no point of time the central representative participated in the committee and he did not comply in the direction.
Yes. Now they have constituted the committee.
So my respectful submission, Lordship, is that the direction of the writ appeal, Lordship, was that committee to be the Chief Secretary to constitute the committee within a period of 1 month, and the committee to take a call take a decision within 4 months and to file a report before this honorable compliance affidavit before this honorable court on completion of 5 months. So my respectful submission, my lord, since the committee is already constituted, my respectful submission is that let the committee file an affidavit by the chairman of the committee after 4 months.
Yes.
So that matter may be listed in the first week of
Takamasa, the senior counsel, assisted by
June.
Mr.
Cindy Long.
Sandy Long, learned counsel for the petitioner. Stop. Mr. Enangame,
Lordship,
learned counsel or government advocate,
Government Advocate, Your Lordship.
appearing on behalf of
Respondent number 1.
respondent number 1 has furnished a notification dated 28 February 2023, by which the expert committee has been reconstituted in terms of the order dated 5/12/2022, passed, no, in terms of the order
Yes, my lord.
dated 5/12/2022, passed by this court in the present contempt petition. Stop. After considering the notification, the expert committee is directed to proceed in terms of the directions passed by the division bench of this court in writ appeal 1 of 2018
Yes, one of the zones.
within a period of 4 months.
My lord,
With
Lordship,
effect-
can you see the condition number 4? It is,
Within a period of 3 months.
yes,
From the date of
the issuance.
the reconstitution of the expert committee. Thereafter, an affidavit shall be filed by the, who's the chairman?
My lord, Mrs. Cindy Young or
By the
MJ.
chairman of the expert committee.
If, my lord, if it is be mentioned by name because it is contempt.
Okay, thereafter, the chairman, namely Shri Cindy Young or MJ, IS, additional chief secretary to the government of Nagaland, of the expert committee shall file an affidavit,
Compliance affidavit, lord.
shall file a compliance affidavit on or before, let us fix a date.
Yes, my lord.
3 months is what? February.
My lord, let it be in the first week of June.
Will happen on 5th June.
Lordship,
List the matter on 5th.
Lordship.
much obliged, lordship.
The notification dated 28 February 2023 is placed on the court.
Lordship. Lordship. Deeply obliged, my lord.
For hearing, item number 22.
May it please your lordship. Your lordship, this is an appeal against a judgment dated 12/3/2019 in MSC case number
12/3/2019.
19, yes. That is
Is it a
annexure
case
3,
of
annexure 3,
accident or
accident,
death?
death, yes. The case was knocked down,
12/3/2019.
yes, and succumbed to his injury. So, your lordship, here in this case, we have filed this appeal on 2 grounds. That the multiplier applied by the learned tribunal is on the higher side because of the variation of the age. And number 2, our ground was the truck was not having the road permit. So it was traveling without the road permit. So the insurer cannot be held liable. That is the 2 grounds. So your lordship, here in this regarding the age.
Records have been called.
Hello. Yes.
Records have been called. Records. Yeah, records. You ready or?
Yes, your lordship, it is a simple matter.
Your lordship, here the deceased himself was a police constable. He was drawing 22,839. That is a monthly salary. And as per the claim petition and the oral evidence of the wife of the deceased type
How much was awarded?
29,000 lakhs. Altogether, the 29,43,392 was awarded. And in the meantime, we have deposited another additional amount of the 50% of the awarded amount. Then again, we are disputing with the age of the deceased. Because,
Was that disputed in the trial court?
no, Your Lordship, the thing is like this. The deceased in the claim petition clearly mentioned that the deceased was 42 years old. And at the time of examining in chief, that is the BW1 is the wife of the deceased. She clearly stated in her course examination that her husband died at the age of 42 years. But in the after that, after completing the evidence without any permission from the court for filing additional documents in the judgment, it is stated that the deceased was died at the age of 35 years. So there is a variation of the multiplier. So we are agitating for that in this appeal. So our claim is if the deceased is died at the age of 42, then as per the multiplier, it should be 16. But the version of this judgment is 35 years. So it comes 16. So there is a difference of one multiplier only. Only one multiplier. And in the meantime, during the proceeding, we have already deposited 50% of the awarded amount. That is our case.
So what more do you want to argue?
No, I'm highlighting my case. That
There's a difference of 1 month.
Only one multiplier. If the deceased is assessed at the age of 42, it should be 15. And as per this judgment, impugned judgment, they have assessed at the age of 35. So the multiplier comes 15.
16.
16. So there is only one difference of one multiplier only.
So if you use 15, how much it comes?
It'll reduce 1 lakh. It is something thousand minus. And I'm not going to agitate on the ground of the road permit because there's no favorable order of the Supreme Court regarding the road permit.
You don't have.
Direction is given.
It's not there.
Yeah, we have to pay and recover from the vehicle owner. That's the thing.
Yes, Tombok.
Your Lordship, in fact, in the
If you are agreeable,
Yes, sir, I have no objection, but based on the record, on the birth certificate, the judgment was rendered. But since it has been a long
that was not
case,
exhibited.
It was exhibited, and based on that only it was. But in the statement of the wife, she has given a statement that her husband is 42 years. But the date of birth certificate, it shows that he is 35. But anyway, Your Lordship, we have no objection. I have instruction from the claimant that they have no objection.
You've withdrawn the 50%?
Yes.
Yes, Your Lordship. Yeah, withdrawn.
Heard Mr. M. Tim Song, learned counsel for the appellant. Also heard Mr. Tompo Conner, learned counsel, appearing for the respondent number
1.
Oblique Clement.
Yes.
Stop. This is an appeal against the judgment and award. Where's the judgment and award?
And that's your tree.
Dated 12/3/2019. Passed in MEC case number 7 of 2018. On the ground that the learned member Motor Accident Claim Tribunal Mokcho had applied the multiplier of 16
yeah.
instead of
15.
Particularly taking into reference the statement of the deceased wife, the statement of the claimant.
Clement, that is the wife of the deceased.
That is the of the claimant that her deceased husband died at the age of 42 years. Stop. Without entering into the merits, Mr. Tompo Conner, learned counsel for the claimant, submits that he has no objection if the multiplier is reduced to 15 instead of 16, and therefore, without 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 entering into the merits of this of this appeal, this appeal is disposed of by directing that the multiplier for that the multiplier should read as 15 instead of 16.
Yes.
So how do we calculate now? I'll have to do the calculation.
If direction is given, then I think we can work it out. Because we have already
To
deposited.
the members.
Yes, no. Where by us, at the time of deposit, we can calculate and we deposit. Because this has to be worked out only the balance amount 50%. Okay.
Supposing if there's a dispute.
Yes, Your Lordship.
While working on, why not you work out?
Your Lordship, now as per the direction of the Honorable Court, we have deposited 50% of the awarded amount.
How much was that?
14 lakhs 46,696 we have deposited out of the total amount. So balance amount, it comes 14 lakhs, same amount is balance amount. So if the multiplier 1 is reduced, so as per our calculation, the difference will be 1,82,712.
1 lakh?
82,712. So from the balance, this amount shall be reduced. So it will come 12 lakh 63,984.
12 lakhs?
63,984.
Stop. You deposit 50% on the order passed by this court?
Yes, already during the pendency of the appeal.
During the pendency of this writ appeal?
Yes, we have withdrawn.
During the pendency of this appeal?
Yes.
It has been withdrawn, Your Lordship.
This court?
Yes, Your Lord.
No. Directed the appellant oblique insurance company. The insurance company, isn't it?
Yes. National Insurance Company.
The National Insurance Company. Which order to deposit an amount of 50% of the awarded amount. Stop. Then the counsel for the appellant submits that they have deposited rupees 14,46,696 before the registry of this court, and which has also been withdrawn by the respondent number 1 oblique claimant. Stop. If the multiplier is taken as 15, then the amount would work out to total amount. Total amount. You have a calculator?
50%.
59 something minus 182 something.
No, 29 lakhs, 43.
15226 into 12 into 15.
28 lakhs, 93,399.
28 lakhs now.
28 lakhs,
93.
392.
392. Nah, minus.
No. Funeral expenses 29,000. 29,000. 15. Yeah, total. 15. 226 into 12 into 15. 15. Yes, how much?
27 lakhs, 40,680.
7 lakhs. 40,000.
680.
680, no? And
Yeah,
then
yeah,
plus 10 plus 10.
Yes, 10,000.
Funeral expense.
10,000 now. Plus.
So it goes to No, 27 lakhs, 27 lakhs, so,
Replaces it, replaces it.
no, yeah, man, only 27 lakhs.
Trong nhầm đi.
Your Lordship, if the calculation is done
15.
with multiplier 15, then it comes to 27 lakhs 60,680. 27 lakhs, no, 27 lakh 40,680. Without including the funeral expenses or loss of consortium.
Stop. What did they say? Other than then you say like this, cancel the tour. Accordingly, the judgment order dated 12/3/2019, passed by the learned member, Motor Accident Claims Tribunal, Mokchung, in MSC case number 7 of 2018 is modified, and it is held that the claimant would be entitled to compensation as under. Then you do 15,226 into 12 into 16 equal to 2740680
Into 15, Your Lordship, not
Yes.
16.
into 15.
Yes.
680. Number 2, rupees 10,000 on funeral expenses. Number 3, rupees 10,000 on loss of consortium. Total rupees 27,60,680. Correct?
Yes, yes, Your Lordship, yes. And then,
Stop.
690.
Accordingly, the appellant is directed to pay an amount of rupees
13 lakhs?
1 minute. 27 lakhs 60,680 minus 50% of the amount that has been
Yes.
deposited
Yes.
before this court within a period of
2 months.
within a period of 2 months from the date of receipt of a copy of the order of this court.
With regard to interest, Your Lordship?
Your Lordship,
Along with interest, you want
Yes, Your Lordship, because
within a period of 2 months.
7 days.
Failing which an interest of rupees 7% per annum
Yes.
shall be added to the awarded amount with effect from the date of filing of this present appeal
yes, Your Lordship.
until the payment is made.
Your Lordship, another, we have deposited statutory deposit of 25,000. So that may be reflected in the order.
You want to take it back?
It depends, but we need one speaking order so that
The statutory amount of rupees 25,000, which has been deposited by the appellant before
Yes.
before the registry of this court, maybe, no, I don't think.
no, if it is allowed to refund it to us, we'll again work out the awarded amount. And if it is awarded in favor of the respondent number 1, then we have to deduct from the balance amount. So my suggestion, Your Lordship,
The statutory amount of rupees 25,000, which has been deposited by the appellant before the registry of this court, shall also be deducted while making the final payment. That will do.
Your Lordship, that, and then the claimant may be
And the claimant
allowed to withdraw the amount.
may be permitted to withdraw the said statutory amount.
Lordship, I'm for respondent number 2, the owner of the vehicle. Lordship, my appearance may also be
Okay,
recorded.
on top, also heard Mr.
Tushio Longkumar, Lordship.
Mr.
Tushio Longkumar.
Tushio Longkumar, learned counsel for respondent number 2. Yes.